Hello, my name is Lori Morgan, and I'm a judge in the Allen Superior Court Family Relations Division located at the Allen County Courthouse. You're watching this video because you have a legal case in the Allen Superior Court and may be attending a court hearing for that legal case that involves the Allen County Department of Child Services. We call those Children in Need of Services or C.H.I.N.S hearings. Court can be stressful, no matter the reason. It's helpful for you to understand what will happen at court so that you can plan ahead and so that we can make your experience as comfortable as possible. If you're watching this video, that means that the Department of Child Services, or DCS, has started an investigation which is called an assessment regarding your children. DCS has received a report from a confidential reporting source that alleges that your family may need help and services in order to provide a safe and stable home for your child or children. After receiving the report, the Department of Child Services must investigate the report and decide whether the family needs help and services. If they believe that your family needs help, they'll decide the best way to give you and your family the help that you need. In order to make this decision, the case manager from the Department of Child Services may be speaking with you, your child, family members, and others who may have contact with your child to investigate the report that was called into the Department of Child Services. After the DCS completes their investigation, they will decide whether to bring the case to court. If they decide to bring the case to court, the DCS will give you several documents that you will need to read before your first court hearing. One of those documents is a report that gives you the results of the department's investigation. This report is called a preliminary inquiry report. The report will tell you why the DCS is doing the assessment, what they found, and what their recommendations are. These recommendations can include whether the DCS will move forward with the case, whether the DCS involvement should be formal or informal, whether the DCS believes that services will be needed and what those services will be, where the children will live, and what type of contact or visitation parents, guardians, or custodians may have with the children. The C.H.I.N.S hearings are held at the Allen Superior Court Family Relations Division at the Allen County Courthouse, located at 715 South Calhoun Street in Fort Wayne, Indiana. Most of the hearings are held on the second floor of the Allen County Courthouse. When you get to the courthouse, you'll see that there's limited street parking immediately around the courthouse where you can park at a parking meter. You can pay the parking meter by using coins, change, or by credit card. Please be aware that if your car is at the parking meter for more time than you paid for, you could get a parking ticket. Another parking option is to park at the Plaza Parking Garage located at 612 South Clinton Street in Fort Wayne, Indiana. Parking rates at the Plaza Parking Garage vary depending on the amount of time that you spend in court. Please arrive 30 minutes before your hearing time so that you have enough time to speak with your family case manager, read any documents, ask questions, and speak with anyone else involved in your case. Please be sure to update your family case manager and/or attorney about any changes in your address, telephone number, or place of employment. When you arrive at the courthouse, you'll go through a metal detector. Please make sure that you do not bring cellular telephones, computers, or other electronic equipment or weapons of any type to the courthouse because these items are not allowed in the building. You must take off your coat, hat, belt, and must empty your pockets when you go through the metal detector. You must put any item that is brought into the courthouse on the conveyor belt to be screened. After you leave the security screening area, you'll go to room 208 on the second floor where you will be greeted by our court staff. If this is your first hearing, you'll be asked to meet with a representative of the Public Defender's Office to be screened to determine whether you qualify to have an attorney, a public defender, appointed to represent you in court. The Public Defender's Office is the office that provides attorneys to parents, guardians, and/or custodians in C.H.I.N.S cases. When you check in room 208, court staff will tell you where to go in our waiting area, where you will quietly wait until your court hearing begins. Please stay in that area so that we know where to find you once it's time for your court hearing to begin. If you must go to the restroom, which is located on the first floor of the courthouse, or if you must step away for any reason, please be sure to tell your attorney and case manager where you are going and return to the waiting area as soon as possible. Please let court staff know if your child is at court with you. The court has a special child-friendly waiting area for children. Please let the court staff know if you have any concerns for your safety, the safety of others, or if there's a no contact order or order for protection involving any of the people attending the hearing. The court encourages children who are 14 years of age and older to participate in certain hearings, if they want to, as long as attending the hearing won't hurt them. Please see the Children in Court policy that's available in room 208, or talk with your public defender, attorney, the DCS family case manager, or CASA guardian ad litem if you'd like more information about this important policy. The first court hearing that you will attend is called a preliminary inquiry hearing. When you arrive at the Allen County Courthouse for the preliminary inquiry hearing, you will meet with a case manager from the Department of Child Services who will give you a preliminary inquiry report that contains the results of the department's investigation. You'll need to read the entire report so that you know the basis of the concerns about the children. If you're not able to read and/or do not speak English, the Department of Child Services and court will make arrangements for the report to be read to you or interpreted for you in the language that you speak. The preliminary inquiry report is a report that's been prepared and filed by the Department of Child Services. In the report, the department is asking the court to find probable cause that the child or children named in the report are children in need of services. Probable cause means that it appears more likely than not that the children are children in need of services based upon the information that's been given to the court. A finding of probable cause does not mean that the statements that are in the DCS report are true. After you've read the preliminary inquiry report, the court will conduct the preliminary inquiry hearing in a courtroom. The department's case manager and attorney will be at the hearing. You will be present, and you will also be allowed to have a support person or family member present. At the hearing, the department will summarize the preliminary inquiry report and make recommendations to the court about whether or how the case should proceed. You will be allowed to comment on the report and the recommendations that have been made by the department. You do not have to make any statements during the hearing. Any statements that you do make during any C.H.I.N.S hearings could be used against you in other court proceedings. This is called your Fifth Amendment privilege. After hearing from the parties, the court will decide whether probable cause exists to believe that the children are children in need of services. If the court finds that probable cause does exist to believe the children are children in need of services, the court will decide the next step. The court could authorize the department to file a petition that alleges that the children are children in need of services, or if the department has requested a program of informal adjustment, the court could approve the informal adjustment. If the court authorizes the department to file a petition, then an initial and detention hearing will immediately be held, and you will be served with a summons, a copy of the petition, and a notice of the next hearing. The court may issue temporary orders placing the children in the parents' care, or placing them with a relative, or in licensed foster care, or in shelter care. The court may restrict or limit a parent, relative, guardian, or custodian's contact with the children. The court may require that the parent, guardian, or custodian begin services provided by the department. The court may also issue additional orders to protect the safety, well-being, and best interest of the child or children. A guardian ad litem or court-appointed special advocate will be appointed for the children. A guardian ad litem or CASA represents the children's best interest through the court case and will come to all court hearings. At the end of the preliminary inquiry hearing, the court will give you the dates for future events, which include the dependency mediation and additional initial hearing dates. Immediately before the additional initial hearing, you will participate in a meeting known as dependency mediation. An independent mediator will lead a discussion to determine if an agreement can be reached about whether the child or children are children in need of services, and about where the children should be placed, the parental contact with the children, and what services should be given to the family. The discussion at this meeting is confidential, and only agreements reached or the disagreements that need to be decided by the judge will be reported to the court. You, your attorney, the court-appointed special advocate or guardian ad litem, and the Department of Child Services case manager and attorney will be present at the mediation. We encourage you to invite family members and other support persons to the meeting. The additional initial and dispositional hearing is held about a week after the dependency mediation. At this hearing, the court will review the admissions and denials and any agreements to services that are listed in the dependency mediation report. The court will also review the predispositional report. If there are enough admissions for the court to rule that the children are children in need of services, the court will enter an order finding the children to be children in need of services. If the children are found to be C.H.I.N.S, the court will order the parents, guardians, or custodians to participate in services that are intended to help the family fix the issues that led to their involvement with the Department of Child Services. If there are not enough admissions to find the children to be children in need of services, the case will be set for a fact-finding trial. At the additional initial and dispositional hearing, the court will also address services for the children. The court will also hear argument and make orders about visitation with parents, guardians, or custodians, and placement of the children. You have a right to deny that your child is a child in need of services and to have a trial called a fact-finding hearing. This is a civil proceeding, not criminal. It's about the care and custody of the child. You will have the right not to make statements that incriminate you, and you have the right to know that an incriminating statement may be used during any court proceedings. Because this is a civil court proceeding, it's important for you to talk with your attorney about the impact that refusal to make statements may have upon your case. The fact-finding hearing is a chance for you and your attorney, if you have one, to respond to what the Department of Child Services is saying happened or did not happen. You have the right to present witnesses or other evidence in your own behalf. You have a right to have the court issue subpoenas or orders to compel people to appear who you want to testify or to produce other evidence. You have the right to cross-examine witnesses who may be called by any party. The right to cross-examination means that if any party puts a witness on the stand and asks questions, you have the right to ask that same witness questions. It's important that you stay in touch with your attorney if you have one, because they will prepare to call witnesses and or give the court evidence to support your position. You or your attorney will have deadlines to file documents with the court and prepare for the trial. In order for the court to decide that your child is a child in need of services, the Department of Child Services must prove that the statements in the petition are true by a preponderance of the evidence. Preponderance of the evidence means that at the fact-finding hearing, the DCS has presented enough evidence to show that it's more likely than not that your child is a child in need of services. If the court does not believe that the DCS has presented enough evidence, then the case will be dismissed. If the court has found that your child is a child in need of services, the court will then hold what's called a dispositional hearing. If there's enough of a basis from the parties' agreements reported from the dependency mediation to find that the child or children are children in need of services, or if a child is found to be a child in need of services after a fact-finding hearing, the court will enter an order finding that the child or children are children in need of services, and then a dispositional decree will be entered which details the services ordered for the family. During the hearing addressing the dispositional decree, the court will go over the individual services being ordered for each parent, guardian, or custodian. The court will then address the child's placement and parent, guardian, or custodian's visitation with the children if the children are placed outside the parent, guardian, or custodian's care. By federal and state law, a child in need of services case must be reviewed by the court every 6 months, and a permanency plan must be entered every 12 months. With regard to your rights, you have a right to be represented by an attorney. You may choose to hire a private attorney, or you may choose to be screened by a public defender's office to find out if you qualify for a court-appointed attorney to represent you. You have a right to have a detention hearing within 48 hours, excluding weekends and holidays, if your child has been removed from your home. You have a right not to make statements that are incriminating and to be informed that an incriminating statement may be used in any court proceeding. You have a right to receive notice of all hearings in your case. To ensure that you get notice about all court hearings, you must give the Department of Child Services your contact information and update the department about any changes in your contact information throughout the time that the case is before the court. You have a right to dispute any allegations made at any of the hearings and may dispute your financial responsibility or your participation in services. You have a right to free access to interpreter services and other accommodations if you have language or physical barriers that would interfere with your ability to meaningfully participate in court hearings. You have a right to appeal the finding that the child is a child in need of services. A C.H.I.N.S case is not a criminal case. It's a civil case and is designed to protect children and to provide services to families to address the issues that brought them to the court's attention. The court understands that most cases involving children impact the entire extended family. The court encourages family members and other supportive people to participate in these proceedings. Please let the court know if your child is a member of or is eligible for membership in a Native American tribe. We hope that this video has helped to better explain the C.H.I.N.S process to you. If you have any questions, please be sure to contact your public defender, attorney, or ask the presiding judicial officer in court. Thank you for your time and your attention to this video.